Civil rules and rules of evidence will be observed in this proceeding. If there is an objection, please wait for a ruling from the chair. After this hearing is concluded, this panel may 1. Dismiss the complaint, 2. Prepare a report to the board that recommends dismissal, or 3. Find the respondent guilty of misconduct and prepare a report for review by the board. If the board finds the respondent engaged in misconduct, the board will file a certified report of its findings of fact, conclusions of law, and a recommended sanction to the Supreme Court of Ohio. Any other matters that the parties wish to address at the time of the panel prior to the relator's presentation of this case? Just relator wish to make an opening statement. Please proceed.
Good morning. May it please the board, my name is John Farrell, and I, along with Bar Counsel Kelly Hyde, represent the Ohio State Bar Association in this case. As neutral arbiters in an adversarial system, judges will undoubtedly receive criticism from litigants who do not get what they want. In the face of such criticism, judges are not permitted to attack with abandon. When they do, it damages the public's perception of the legal profession and the judiciary. The damage is amplified on social media, where thousands of people can view a judge's public comments in an instant. And because judges occupy positions of authority and are perceived as legal experts, a judge's attack of a litigant on the court's official Facebook page is especially damaging. For several years, the respondent, Judge Winkler, presided over a contentious guardianship of Mary Frances McCulloch. Her son, Rob McCulloch, was dissatisfied with the court's action in the guardianship and submitted several complaints to the court expressing his dissatisfaction. In January of 2019, Judge Winkler's assistant court administrator, Scott White, told a reporter, Katie Ellington-Zarala, that Mary Frances McCulloch was removed from her home because it was a squalid, unsafe living environment, and that Rob McCulloch was not properly caring for her. This statement is entirely unsupported by the record. Then, over 3 years later, on October 7, 2022, Rob McCulloch posted a criticism of Magistrate Kendall Coase on the court's official Facebook page. Without reviewing the record, Judge Winkler responded, echoing the unsupported statement provided to the reporter 3 years before. In addition, Judge Winkler accused Mr. McCulloch of elder abuse and claimed that his
Did you have policies and practices related to deleting or hiding negative comments?
Yes.
What was that?
If they were inappropriate to the post, they would be deleted. And if they had any bad language, they would be deleted. So the only other one I can recall being deleted would be, I had an adoption once where the person thought I was his probation department, which was a criminal case. And he was talking about his criminal case, and the adoption post was about the family's happy day, not about his criminal case in another court. So I do remember myself or another administrator deleting that. So I might be able to think of another one, but I might have an adoption once where an unrelated person said that the government basically stole my children and took them away illegally on an adoption that wasn't even their case. So I vaguely remember maybe removing something like that. But those are the only two I can remember, and the second one I'm not totally sure about.
And were those practices of deleting or hiding the comments, were those put in place when you took over that Facebook page?
Yes.
I'd like to direct your attention to exhibit 1028. Take a moment to review that,
I've seen it many times.
and you recognize what that is.
Yes.
What is that?
It's a post that I made on the same Facebook page that we're talking about today.
So exhibit 27, that was a post you made under the magistrate code's Facebook post.
I think it's 28,
I'm sorry, exhibit 28 is that, exhibit 27 was the magistrate post.
right?
Thank you for correcting me.
Thank you. I didn't really want to, but I did anyway.
It's appropriate. All right, so those Facebook posts that you made, those were in response to something?
Yes.
And what was that?
Rob McCullough, or someone identifying as Rob McCullough, posted something that he had brought up before, I can't recall how many times, about my court basically being corrupt and Kendall Codes being corrupt and everyone related to his mother's case being corrupt, essentially.
And then you made these Facebook posts, it's actually two separate posts, is that correct?
He had a post in between those, but I can't recall what it was anymore, but I did make these two posts.
And I think it's already up there, but I request permission to publish exhibit 28.
Granted.
You agree that exhibit 28 is a verbatim recitation of what you wrote, is that correct?
Yes.
And I know you mentioned these are two separate posts, so you would have typed the first post beginning with Rob McCullough and ending with the case file and actually hit post or send or a little arrow with that, correct?
Yes.
And then you typed the second portion beginning with you lost your case and ending with help her, and again you hit post from that, is that correct?
Yes.
You agree that instead of posting those comments, you could have just deleted or hid the comments from Rob McCullough, correct?
Yes.
You agree that the guardianship case of Mary Frances McCullough was still open at the time that you posted these comments, is that correct?
I didn't realize it for sure until after it was brought to my attention. It was a case from 2013, I believe. And so I can't, so I would say I wasn't sure at the time I made the post. But if I stipulated to it, then I'll say guardianship cases are supposed to be non-adversarial in general. This case certainly was not. So he was involved in the case, and he was sending letters and showing up for court occasionally, but he was never a plaintiff or a defendant or someone that applied to be his mother's guardian. So it's a hard question to answer. Sorry to give a long answer, but under the pure definition of litigant, I would say no, he was not. He was a family member of his mother who was under guardianship in my court. I don't want to split hairs on it, but he never applied to be his mom's guardian, and he never made a motion to intervene. We're very informal with the guardianships. If we get a letter, we put it on the docket, because we want to make sure that the ward is not being abused by anybody or being hurt in any way. So if a concerned citizen wrote a letter on a case, we would put it on the docket, bring everybody in and say, let the magistrate would say what's going on with the case. So I'd have to look up the Black's Law Dictionary of